Hello and welcome to the Minimum Competence episode for Wednesday, January 8th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, CFPB is suing Experian, TikTok Supreme Court showdown over a U.S. ban, Alaska's lawsuit on Arctic drilling restrictions, and my column on Pittsburgh's so-called jock tax. Let's remember, life doesn't get easier or more forgiving. We get stronger and more resilient. And read today's legal news. On this day in legal history, January 8th, 1867, the U.S. Congress overrode President Andrew Johnson's veto to enact the District of Columbia Suffrage Act. This landmark legislation granted African-American men the right to vote in the nation's capital, making it the first federal law to extend voting rights to black men. This milestone occurred 3 years before the ratification of the 15th Amendment, which would prohibit racial discrimination in voting nationwide. The act was a significant step during the Reconstruction era as the United States grappled with integrating millions of formerly enslaved individuals into its civic life. By enfranchising black men in Washington, D.C., Congress set an example for the expansion of voting rights elsewhere in the country. However, the process was not without contention. President Andrew Johnson, a Southern Democrat, opposed the bill, reflecting his broader resistance to Reconstruction policies that aimed to promote racial equality. Congress's decision to override Johnson's veto demonstrated its determination to lead Reconstruction efforts and address the injustices of slavery. This vote also highlighted the tensions between the legislative and executive branches over how to best rebuild the nation after the Civil War. The District of Columbia Suffrage Act stands as a pivotal moment in the fight for civil rights, symbolizing the beginning of federal measures to ensure greater political inclusion for African Americans during a transformative period in American history. It also illustrates just how much of a jerk Andrew Johnson was. The Consumer Financial Protection Bureau, or CFPB, has filed a lawsuit against Experian plc, alleging the credit reporting company failed to properly investigate consumer disputes and ensure the accuracy of information on credit reports. According to the CFPB, Experian did not adequately collect or relay dispute information to data furnishers, sometimes accepting illogical or unreliable responses from credit card companies and debt collectors. These practices led to inaccurate information on credit reports, which negatively impacted consumers' credit scores, potentially resulting in higher loan interest rates, limited housing opportunities, and employment challenges. The CFPB accused Experian of violating the Fair Credit Reporting Act and the Consumer Financial Protection Act by conducting inadequate dispute investigations. Director Rohit Chopra criticized Experian for, quote, sham investigations and emphasized the importance of compliance with federal laws. Experian has denied the allegations, calling the lawsuit an example of regulatory overreach and claiming the agency did not respond to prior communications. The company highlighted its history of working with the CFPB to improve dispute processes. The lawsuit builds on prior CFPB actions against Experian, including a $3 million fee in 2017 for misleading consumers about its credit scores. The current case alleges persistent systemic failures in Experian's dispute handling and reporting processes. A Supreme Court case this week could determine TikTok's future in the United States, pitting national security concerns against free speech rights. President-elect Donald Trump has asked the court to block a pending U.S. ban on the app, citing First Amendment concerns, while many Republican lawmakers and state attorneys general argue for upholding the ban. The law, passed by Congress and signed by President Joe Biden, requires TikTok's parent company, ByteDance, to sell the app or face a ban by January 19th over fears of Chinese government access to American data. TikTok and ByteDance contend the law infringes on free speech, warning that it could set a dangerous precedent for banning platforms with foreign ties. Trump, in a reversal of his earlier stance, now opposes a ban and sees TikTok as politically valuable. The Justice Department defends the law, citing national security risks, while Republican attorneys general argue that TikTok's ties to China pose significant dangers. The court's decision could have far-reaching implications for digital platform regulation and internet freedom in the U.S. and beyond. If upheld, experts warn other foreign-backed platforms, such as Telegram, could face similar scrutiny. Meanwhile, tech giants Apple and Google have been asked to prepare for TikTok's removal from app stores, potentially rendering the app obsolete over time without updates. The state of Alaska has filed a lawsuit against the Biden administration alleging violations of congressional mandates to permit oil and gas development in the Arctic National Wildlife Refuge, or ANWR. The lawsuit challenges the Interior Department's December 2024 decision to impose restrictive conditions on drilling leases in the refuge's coastal plain, arguing the limits make development impractical on the 400,000 acres set for auction. Alaska seeks to overturn the decision and prevent the leases from being issued with the restrictions. Governor Mike Dunleavy criticized the Biden administration's stance, claiming it undermines U.S. energy independence by restricting access to domestic resources. Alaska argues the restrictions, combined with the administration's earlier cancellations of leases granted during Donald Trump's presidency, significantly reduce expected revenue from ANWR development. The Biden administration has prioritized environmental protection for the 19.6 million acre refuge, home to species like polar bears and caribou. This legal dispute is the latest in a series of lawsuits from Alaska opposing federal efforts to limit drilling in ANWR. The battle reflects ongoing tensions between environmental priorities and energy development in the region, a long-standing political flashpoint. And in my column for this week, I talk about the facility fee charged for non-resident performers and athletes in Pittsburgh. The Pennsylvania Supreme Court is set to rule on the constitutionality of Pittsburgh's so-called jock tax, a 3% fee imposed on income earned by non-resident athletes and entertainers at publicly funded venues. This case raises complex questions about tax uniformity under the state constitution, as opponents argue the fee unfairly targets a specific group of workers, that would be non-resident athletes and entertainers. The city contends the fee achieves fairness by equalizing tax burdens between non-residents and residents. Residents already pay a combined 3% in local taxes. Without this 3% fee, non-resident performers would enjoy a tax advantage over residents, who contribute to funding public infrastructure and services that benefit everyone using the city's venues. Critics claim the tax violates uniformity principles by singling out non-residents in certain professions, those would be athletes and performers, and asking them to pay 3% despite not receiving access to services ostensibly paid for by the tax, like the local school system. But taxation has never operated strictly as a direct exchange for services rendered. Much like HLA Hart's No Vehicles in the Park thought experiment, interpreting uniformity in taxation requires considering intent. The fee's purpose is to ensure non-residents contribute their fair share for the public resources they use, aligning with broader fairness goals rather than rigid formalism. Rejecting the fee would create an inequitable system where non-residents effectively have their use of public resources subsidized by residents. For Pittsburgh and other cities balancing local budgets, the facility fee represents a practical, equitable solution that respects the principles of shared responsibility. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the oak fought the wind and was broken. The willow bent when it must and survived.